everybody. Welcome to the first teach-in of the semester. I'm Professor Ralph Young in the Department of History. Five of the teach-ins we'll be hosting this semester will be dealing with a specific theme of politics, the Supreme Court, and democracy, in which we'll be examining the significance of the recent controversial Supreme Court decisions on reproductive rights, gun violence, immigration, and climate change. Next week's teach-in will be on Thursday, September 15th, with Professors Amy Sinden and Mohammed Kiani on the Supreme Court and climate change. I want to especially thank Provost Mandel for suggesting the scholars who will be participating in this series. And to kick off the series today, he will be hosting a panel discussion on the politicization of the Supreme Court. Gregory N. Mandel is the Provost and Senior Vice President at Temple University and the Peter J. Leocoris Professor of Law at Temple Law School. Prior to serving as Provost, he was Dean of Temple's Beasley School of Law for 5 years. Provost Mandel is a leading international scholar on intellectual property law, innovation, and interface among technology and law. JoAnne Epps has been a member of the Temple Law faculty since 1985, teaching in the areas of criminal law, criminal procedure, and trial advocacy. She is a former dean of the law school and former university provost. Professor Epps is a member of civic, nonprofit, and public company boards of directors and is frequently sought for insight on issues of diversity, equity, and inclusion. Craig Green is Professor of Law at Temple Law School. Before that, he worked for the Department of Justice and was a law clerk for then Judge Merrick Garland. He specializes in legal history, but has written about modern issues such as the administrative state, environmental law, federalism, and Guantanamo Bay. Chloe Bakalar is assistant professor in the political science department. She is a moral and political philosopher who specializes in U.S. constitutional law. Her research focuses primarily on the intersection of First Amendment liberties, especially freedom of speech, democratic citizenship, and technology, which is the focus of her book project, Small Talk: The Impact of Social Speech on Liberal Democratic Citizenship. She also consults with tech companies on the broader space of AI ethics and governance. So now let me turn it over to Provost Mandel to kick off the discussion today. Thank you.
Thank you, Ralph, and thank you so much for inviting me to take part in this. It's an honor to be, for the first time, a part of this Temple institution. The teach-ins that you've been putting together for our community for a very long time, and I appreciate that. Good afternoon, everyone. It's wonderful to see all of you. I'm thrilled to see a number of my colleagues, and in particular, thrilled to see so many students who are taking part in this sort of kickoff discussion at the teach-ins around the politicization of the Supreme Court. As Professor Young mentioned, we're going to try to set this up to discuss both the instant topic of that politicization in general, but also provide folks with some of the tools and thinking that might be useful for the other teach-ins that are going to take place during the semester. I'm really glad that you're interested in this topic. I'm really glad you're taking the time to interrogate an incredibly important question for us. In a democracy, legal systems form the backbone of how we choose to order society. And there have been many challenges to our legal system, to our justice system over the course of American history. We're living through a period of significant challenge now. I think it's probably safe to say that public concern about justice in the legal system has rarely been higher. And so I'm really pleased to see so many people interested in this topic and thinking about where we are, and even more importantly, a little bit about what we can do or how we think about trying to move things forward. Probably needless to say, the hour or so we have for this topic is barely enough to scratch the surface. We could spend an entire course on these issues. We have some such courses at the law school. There's lots of pieces here, but hopefully this teach-in will provide some introduction, whet your appetite for the topics, increase your understanding of the topic, and as I said, give you some tools for the series of teach-ins that are planned throughout the semester. I want to thank JoAnne and Craig and Chloe for agreeing to take part in this panel. A wonderful group of folks who are going to share their insights with all of us. So for the format we've put together for this afternoon is that I'll serve as a moderator and have developed several questions that we'll begin with, that I'll ask our panelists about to get us started with the topic, to lay some of the groundwork for it, some of the framework for how we might want to think about things, some different viewpoints on it, and we'll go through that. And we'll get through that in time to leave significant time, sufficient time for a lot of Q&A. We certainly want to hear all of your questions. We want to dive into those and work on topics you want to focus on as well. While we're doing this more purely panel part of the conversation, I encourage you not to use the group chat. If you do have questions that come up, feel free to private chat me. I think you can private chat Professor Young as well. But sometimes it can throw folks off course if the chat starts to flow while they're talking. So send me your questions. I'll put them together. We'll get to Q&A, or I'll call on you afterwards, and we'll get to Q&A and cover that as well. So let's, with that as intro, let's go ahead and dive in. And, I think to start at the beginning, right, as we ask the question about the politicization of the Supreme Court, that's fundamentally a question about how we should understand and think about judicial decision making, right? It's a question about judges are making a decision in one way, or we think judges are making a decision in one way, and we think that actually they should be doing it in a different way. So what is the appropriate way for judicial decision making to take place? The Supreme Court has to handle a number of heavily contested political issues all the time. What would appropriate non-politicized decision-making look like? And for that, Professor Bakalar, if I can start with you, and then we'll open it up to the other panelists as well, but please share your thoughts there.
Sure, and I'm going to start by channeling the philosopher side of me and dispute, or at least complicate, the premise that the Supreme Court is politicized. We've all heard that the Supreme Court, or the judiciary anyway, is supposed to be the least political branch. Some people may even think that it's supposed to be apolitical, but we know that it never was and really never could be completely apolitical. The appointments and confirmation process is inherently somewhat political, but to me, more importantly, at least, the art of constitutional interpretation is inherently a value-laden process. Right? There's some politics that makes its way into the simple reading of a text, right? There's no value neutral way to approach a text. And that may not have been initially all that obvious. In fact, it's pretty clear that in the early years of the Republic, people did not think that that was obvious. There was a lot less discussion about constitutional interpretation in the very early years of the Republic, maybe in part, right, because some of the people who wrote the Constitution were actually still alive, so we could consult what they actually meant. Not enough time had passed, right, for interpretation to be as complicated a notion as it became, as it's become today. And so we had visions of constitutional interpretation or judicial decision making around like the plain meaning rule, just the idea that you're supposed to take a common sense understanding of the text, and that's what it says, and that's how judicial decisions should be rendered. And that plain meaning rule came along with us for a while. It wasn't really until the 19th century, beginning of the 20th century, that we started getting justices complicating that question. So Oliver Wendell Holmes, for example, argued that you couldn't just uncover and declare law, but the process itself of interpretation involves some amount of value judgment, some amount of political judgment. And then others at the time went even further. We had the Harvard Law School Dean, Roscoe Pound, arguing that justices shouldn't just embrace that there's some amount of themselves that goes into interpretation, but that they should be active, they should be proactive, seeking guidance when they're interpreting the Constitution from empirical studies and even quantitative and qualitative analyses. So these intellectual battles brewing at the early 20th century, late 19th, sorted themselves into two broad schools of constitutional interpretation: positivism, which tended to be more closely linked to the text itself, and realism, which moved a little bit further in embracing the interpretive role of the justice. You don't have to go into too much detail there, but really the point I want to get across is that reading a text, even if you're trying to stay close to the meaning, always involves some amount of interpretation and is never totally the end of the story, right? When justices are making decisions, the text is there, but they have other things that they're keeping in mind. At least 5 other criteria that we might think of as legitimate go into decision making at the Supreme Court level, right? One of these is a commitment to coherent law, right? We have the principle of stare decisis, let the decision stand. The idea that we want to generally have jurisprudence that is coherent and consistent and predictable, even if that's not always the case. And that influences the kinds of decisions that get made and how the Constitution gets read. A second, hopefully we'll get to talk a lot about this today, is the perceived legitimacy of the court, right? The court has neither purse nor sword. It gets its rulings enforced in part because it's seen as legitimate and the other branches play along. So that is part of judicial decision-making too, making sure that the court remains seen as legitimate. A third factor is meeting the systemic needs of a political system. Cases don't just come entirely out of thin air. There are actual cases with actual people with actual needs that need to be addressed. And so the context of a case, the particular circumstances there often do and ought to impact decision-making. Say a fourth, I'm almost done here, concerns for judicial power, right? We may think that as with any other political actor, any other representative, they're going to be concerned with staying in power and perhaps even increasing power over time. And yeah, judges are people too, right? Until they get entirely replaced by robots, they're humans with personal and political preferences, and how we could entirely disentangle those preferences from their understanding of what is just and right, and in keeping with the fairly vague and open to interpretation principles of the U.S. Constitution is hard to imagine where that crosses over from being a natural human bias that's impossible to eliminate into a politicized and problematic Supreme Court. I guess that's the subject for today.
Thanks, Chloe. That was very good. Craig or JoAnne, anything that you want to add there to sort of this introductory discussion about how we should be thinking about the question of whether the court is politicized or what it means to call the Supreme Court politicized?
If I might, I would just ask the students in particular to remain open-minded about whether or not the premise is off. I reject wholeheartedly the notion that just because judges are humans and because inevitably they are going to be deciding things in context, that's the same as giving them permission to be influenced by small p political things. So I don't think that's what Chloe said. I don't mean to put those words in your mouth, but I would just encourage our students to remain open-minded about whether there are in fact limits to what we think is appropriate or not.
Yeah, and I actually want to take one step back, because I just want to really say how excited I am to be here. Just for a second, 30 seconds, I want to say it's really great to have our terrific Provost Greg, and of course everyone has already seen Chloe's such a brilliant addition to poli-sci. But JoAnne Epps, you should Google her, because I think it's fair to say she's done more for Temple in this region than everyone on this call combined. So this question of the role of politics in courts, one of the claims about law that I think is really important. Let's think about what the biggest picture, what matters. There's private capital and money. There's elected officials and politics. And then there's a claim about law that is, of course, mixed in with some of the things, but claims to be a little bit separate, at least a little bit separate, this idea of law and the Supreme Court. And I think one reason why so many folks have taken their Friday afternoons, a beautiful Friday afternoon, I dare not mention, but have taken this time is because the Constitution and the Supreme Court and the law is thought to matter in a very important way. And the extent to which judges and law and legal reasoning and constitutional logic especially are unable to show some kind of separation from ordinary politics, I'll say, and from money, I think that's a real threat and a danger to why even have the courts, why even have sort of, you hear this all the time, the unelected 9 people with black robes and funny uniforms come up and say sort of, oh yeah, or whatever. So I think that's the challenge. And I think Chloe did a very, very thoughtful job of tracing that sort of question over time. Lots of different people have lots of different answers, but everyone's here because there's a particular moment right now where there's a challenge to whether these judges and this court rendering the decisions that will be studied this whole semester in teach-ins, whether those things are true to the traditions that have tried to maintain that kind of partial separation from money and from elected politics, or whether they really haven't. And so I think that's another way to think of what's at stake in this question of whether the political and the judicial, never fully disentangled, but whether they have become merged in newly dangerous ways.
Thanks. Yeah, no, that's very helpful. And I'll sort of pick up off of what everyone just said and add maybe one or two quick things. One is to make the point that when people talk about the Supreme Court or any justice, any judge being politicized, it usually means they disagree with a particular decision that person made. But obviously, it has to mean more than just you disagree with that decision. So sort of as we think about this question, probing a little bit of that, what is it that makes me say that decision was politicized, as opposed to, right, I disagree with that decision. If they had come out the other way, would you feel differently? I think it usually has something to do with process. It maybe have to do with the process of the way the person made the decision, or you view the person making the decision. It may have to do with the process by which they got appointed to their judgeship. But I think that's a piece which it's worth us pushing on a little as we talk further. Let me actually, I'm going to stop there because I want to keep us moving through some other questions. So if that's sort of a little bit of a conversation about what maybe judicial decision making actually looks like or should look like, or where we want to get somewhat idealistically, I think it's worth spending a little time on talking about how we got here and what led up to the current situation where the discussions about the Supreme Court being politicized are being raised pretty significantly. But that didn't happen overnight. And there's been a long history of the Supreme Court in the United States. There have been other periods of politicization. I thought it would make sense for us to spend some time to understand the history and the events that have led up to where we are now. And Craig, given your expertise in American legal history, I was hoping you'd be willing to start us off with on this topic.
Sure, great, thanks. So I think for people who want to think about the past, I would offer 2 examples that kind of frame the modern discussion. One of them's around the New Deal, where people may remember it's discussed sometimes in the news. President Roosevelt had in mind and proposed to expand the number of the Supreme Court justices so he could pick more people he agreed with and thereby wrench the entire course of American law to the left. So that was a dramatic political moment in the history. Another is the Warren Court, when, for example, a range of decisions, criminal procedure, racial school desegregation, First Amendment rights, a lot of things were happening, and there were even billboards that said "Impeach Chief Justice Earl Warren," and I think you can easily imagine how much John Roberts would like that kind of thing today. So then in the modern context, what brought us to here, to now, to this moment, I think there's at least maybe three things. And one is an election, who can even remember that far back, a very close election where President Trump won the Electoral College by 70-some votes and lost the popular vote by nearly 3 million. And that was a little unsettling for a lot of folks in America. Now, then that combines that election and that presidential election, very close election, which I don't have to say, which President Trump won. I just want to say, like, for the record, he did in fact win that election. But then it combined with judicial appointments that ended up feeling really, in this line of process that Greg was mentioning, felt really even more a kilter and more off base, where my former boss, Merrick Garland, spends 293 days as a nominee without the Senate even giving him a hearing. Unprecedented delays no one would have thought possible. No one could do such a thing. And the Senate delayed, refused to hear his nomination so that the newly elected Trump could pick someone to succeed. And then, of course, Brett Kavanaugh with the politics and allegations of sexual assault that surrounded his nomination. And then Justice Ginsburg dies, just weeks before the election, and the Senate, the same Senate, rushes through Amy Coney Barrett in a way that they totally, more than slow walked, they lay down on the tracks and rolled the other direction for the nominee, Merrick Garland. So then the third thing is you have this sort of tense, close political presidential election. You have these very highly aggressive hardball judicial nominations that then produce a 6-3 supermajority that has never been seen in any living person's lifetime. And then the third thing is they come on and they start making decisions that are self-consciously radical, with the Dobbs decision concerning abortion as the primary example. Of course, you'll have a teach-in on that. With the recent climate change decision as another example, you'll have a teach-in on that. There's like one big ad for teach-ins, but I think these issues, and the guns decision, right on target. So I think those three things together, the very contested political election, not this one but the one before, this very hardball manipulation of the actual personnel on the court, producing a 6-3 supermajority, and then they take that and run with it. So this other process point. The procedures and the reasoning, they're throwing over 50 years of precedent or more routinely in cases, saying we know the truth and to heck with the rest. And I think that's very unsettling for the nature of law, the stability of law, the process of law, the believability that this is really a constitution instead of political views or politics through judicial means.
Thank you very much. Thanks, Craig. JoAnne or Chloe, do you want to add anything as we think about the history here?
Well, I'd like to first add that thank you, Craig, for reminding me of my manners. I was so excited before to start talking. I didn't thank Greg and Ralph and everybody for having me here. And Craig, thank you for reminding me of that. But then also, I think you're making a really fascinating historical connection, right? It's easy to think in deeply politicized Supreme Court times that this is something entirely new, and that might be the case right now, but keeping it in context with other political courts that we've had, what makes this different than those? Are they different? I think are the questions that we ought to be asking. Is this another case of the Warren Court just in a different direction, or is it something qualitatively different? And both you and Greg brought up the concept of process, right? This the distinction between justices becoming justices or judges becoming justices through what are seen as politically illegitimate means, and that being one kind of politicization of the court. And then the content of decisions being another kind. We might be finding ourselves in a moment where we feel both of these things are happening, that the process was illegitimate and the decisions themselves are too politicized and thus illegitimate. But just calling out that they're separate, and it could be that we feel one way about the process and another about the content, right? It could be that we got very justices in this new court through a very politicized process that some might deem illegitimate, but the content of their decisions could be perfectly fine. It might not be, it might work in the reverse too. So just disentangling these two components.
Thanks, Chloe. Yeah, and very important points. And I think it's, the process that's designed for appointing justices is inherently political because it involves the Senate voting, and that's gone through different periods of politicization over time. In the 19th century, Congress rejected about 1/3 of the presidential nominees to the court. So rejection of presidential nominees was common. In a period in about the 70s and 80s, there were many unanimous or nearly unanimous votes for both democratically nominated and Republican nominated justices. And then beginning with the Bork nomination in the mid 80s, we've sort of hit a period where it's become much more politicized, at least in a small p political way. And I think, as Chloe was describing, it's very useful to think about some of the different reasons that there are partisan battles over nominees, over Supreme Court nominees. Some of those have involved questions concerning, or focused primarily on questions concerning a justice's background. The Clarence Thomas nomination, the Justice Kavanaugh nomination fall into that category of questions over their background. Some have concerned challenges to the confirmation process itself. And Craig spoke about the process for Justice Gorsuch and Justice Barrett. And then some have focused on the nominee's ideology. And certainly I think Justice Bork's nomination was one, and the process we just saw around Justice Jackson the opposition was focused, I would say, pretty purely on ideology. So there are a variety of reasons we see there. We can measure that the court is now viewed, or justices are viewed through a very partisan lens. Again, going back to about the 1980s, over 50% of Americans said that they had a lot of confidence in the Supreme Court. Just before the Dobbs decision that Craig mentioned, only 25% of Americans responded that they had a lot of confidence in the Supreme Court. And you can, I think you can make guesses about whether that went down or up since then, but we've seen a change there over time. So that's sort of the overview of the question. We've talked about the history. Let's talk about what this means for the court and the nation, which is perhaps the most central question for us to focus on. What does the current politicization mean? How does it impact the court? How does it impact the country as a whole? And here, JoAnne, I'd like to start with you sharing your thoughts.
Thank you, Greg, and thank you to my two colleagues. Craig, thank you for those very kind comments, and Chloe and Craig, thank you for reminding me too to thank our host, Ralph, and Greg for moderating. It really is an honor to be a part of this, and Chloe, it's really great to get to meet you, even virtually. I think I would start by saying that I think I hold a slightly different perspective on the importance of this question. I think it is cataclysmically important to the future of the nation that we think about this question and address it. And let me put it in personal terms. As a woman and a person of color, I have said in earlier times, and I would repeat today, I would walk across this country to protest for the right of the KKK to have free demonstrations, as much as I wish they would just evaporate and go away. Of course, they're not as prominent as they used to be, but I think you take my point. To me, the answer isn't just whether I like the decision. I think that's too simplistic, though, Greg, I think you're 100% right. That's what gives rise to many people's reactions. But I think the question is more consequential than that. And for students in particular, I would encourage you to think about what the right way to judge should be, then the right way to pick judges. So I think the right way to judge is that you try to do your best to make the right compelled decision, whether it violates your own personal preferences or not. Now, I would agree with Chloe and Craig that certainly this isn't the first time this question has arisen. And I think certainly there are times in the historical past where I might have criticized the courts, even if I was in favor of their decision. I was born before Brown versus Board of Education, so I've benefited from that decision. I think it was legally defensible and legally compelled, which in my mind are the two things that say what a judge should do. A judge shouldn't look at something and go, what would I prefer? What would I like? What would my political leanings prefer? What does my religion tell me? Those are all, in my mind, off the table. I'm a purist in that regard. But I also understand that one might be seen to be naive in thinking about that. But I think what I would say to end this part of my point, if pre-Dobbs only 25% of our nation believed in the legitimacy of the Supreme Court, and I'll just take the bait, Greg, I think it's probably gone down since then. That is really scary. It is really scary. And I think for people who are students of these issues, you should understand that, in my judgment, the future of democracy in America is tied up with the belief that the Supreme Court is doing the best they can with the disputes before them based on history and law and precedent, and casting aside the things that they might wish otherwise. So for me, I find this so unbelievably important. And I'm very grateful, Professor Young, for your gathering these group of people and us to begin thinking about it, because the issues are important. The answers are not easy.
Thank you so much. Chloe or Craig, you want to add anything to that?
Yeah, I mean, I just think that it's if you imagine, just picking up the very last point that JoAnne mentioned, there could be an electoral controversy. There could be a question about, basic questions of law. And if the court isn't credible, and I think there have been real challenges to its credibility in the now, then I think that those other factors of money or venom or raw politics can really damage basic structures of the American society and government. And so I just couldn't agree more. The extent to which this court damages its own institution through the reasoning and the decisions it makes, I think that just hurts everyone in the country, and quite frankly, in a way that's hard to imagine for most of us alive today.
I fully agree. I said earlier the courts never could be entirely apolitical. But it matters that people think that it's not being politicized. It matters that, the people in this country feel like it's not an arbitrary institution that's arbitrarily making decisions based on their own personal preferences or the preferences of their political donors. It's impossible to entirely pull politics and values out of judicial decision-making, in my view. But there is value in trying to do as much as you can in that regard, and certainly in trying to uphold the court as being above politics, even if at the end of the day it makes its way in there. And to the extent that courts or justices don't or no longer feel the need to present themselves as being outside of small p politics, we have a real legitimacy problem, and we have one that has enormous ramifications, not just in the areas that we're discussing today, but for the entirety of the US constitutional system.
Greg, can I ask Chloe a question?
Please.
Chloe, twice you used values and politics in the same sentence, the sense being that human beings are going to be affected by both their values and politics. I'm curious as to whether you see those two concepts as essentially overlapping, or whether they're different, whether you could differentiate them and make one more appropriate than the other. First, did the question make any sense?
Yeah, no, that made sense. And that's a great question. Thank you, JoAnne. Maybe in an ideal world, our politics perfectly represent our values. The reason that I separate them out is because I think, there's what people hold to be important to themselves, right? The values that they think are most important. And then there are all sorts of other factors that may impact on what we might hold as our political opinions. So you might value liberty above all else, but in the world of politics, you have to make compromises, and you have to apply those to real world situations where you're going to have to make trade-offs between the thing that you value and perhaps other things that you value, or just in order to get things done. So that's the only reason that I'm separating them out. A beautiful, idealized political world would be one where we felt empowered to treat politics and values the same way, perhaps.
Thank you.
You're welcome.
Thanks. I have one more question I want to ask of the panel before we turn things over for a more general Q&A. So I hope you'll start thinking about your questions. Feel free to send me a direct chat if you've got one that you want me to ask, but we'll also we'll call out for them if you want to ask it. And so, I think there's a certain pessimism in the conversation we've had so far about where things are, and the concerns around politicization, concerns about the legitimacy of the court. So on hopefully and at least slightly optimistic front, let me ask folks, what are your hopes for the future of the Supreme Court, its decision-making processes, its role in our government? Do you have any recommendations that, realistic recommendations that might improve the situation? Do you anticipate that things will get better from here? Anybody willing to start that one off? Craig or JoAnne or Chloe?
No optimism. I've been repeatedly disappointed by America when it comes to the courts. I feel like for at least the last 6 years, I and a large range of fora, from podcasts to speeches to academic work to public political organizing, trying to get Americans to pay more attention and care more about the federal courts. And I get it. There's an awful lot of other things on a lot of people's plates. But in terms of thinking about how maybe now people will turn more attention to the court or whatever, I have to say my own record is a bunch of potholes and detours. But I think the thing that I would say is, I think you see this that's what's on everybody's mind is Dobbs. But, I think you see this with Dobbs. Affirmative action will be struck down within 12 months. The Supreme Court will really take serious steps backward in the constitutional analysis pertaining to racial justice. But I think time and again, Americans who have not focused on the court, and now in a sense, it really is too late for the court because these justices are here for probably at least 10 to 15 years. But I think it's time for people to think about political values and politics, to think of those things, what they can do outside of the court and aside from the court. And of course, you see that with the climate change legislation, and you see that with California trying to step up. And I think you see in the context of abortion, reproductive justice, you see private organizations, companies standing up for their employees, in addition to protests, in addition to laws. There are elections, including in the Commonwealth of Pennsylvania, where those topics are hotly discussed, and where Americans who have not taken responsibility, it seems to me, for basic norms and processes and structures of the court have not. And it's kind of too late, where they have to stand up for those values in other fora if they care, and I hope that they do. So I think in a way, the short run to medium term is very predictable, given that you put the personnel in the court and you get the decisions that result from that. But I think the idea of what America can do, if America can take step forwards, then maybe they, in the long run, can lead the court to a better way.
Thanks, Craig.
Chloe, you go and then I'll add.
Sure. You know, the Federalist Papers, we have this epithet of the court, the least dangerous branch, right? This sleeper branch that nobody thought initially was going to be all that powerful, all that influential. And here we are now in a moment where it seems like the Supreme Court in some ways is more powerful than any other piece of the government. They can overrule popular preferences. They're not accountable in the way that we had perhaps initially hoped, or the system was initially designed to be. So I share a lot of Craig's, I don't know if you'd call it fear, but lack of optimism at the very least. And I just tried to remind myself that, you know, we've had active courts, we've had activist courts before. One thing that makes this one so scary and so different is that as they're overturning precedent, as they're moving away from the thread of history, it's in a direction of taking rights away, right, instead of giving rights. And that's a huge departure, and something, a step that can never be taken back. So that's very scary. I'm not sure what the court should do, but I agree with Craig's assessment that there's things the rest of us can do, and there are things that the other branches can do. We've already seen federalism getting a strong showing, not just from the right, but from the left in recent years too. States trying to assert their rights and state powers a bit more as a counterbalance to what's happening at the federal level, and maybe that's a way to reinvigorate local politics, which from a political scientist is always a good idea, right? Local is where politics happen, and maybe people aren't thinking or going to be thinking about the Supreme Court as much as they should, but if they're thinking about who they're electing to their city council, who their mayor is, who their governors are, state legislatures, that'll be a huge step forward for democracy, and potentially one way to protect the rights of many of the people who are currently in fear about what the Supreme Court has already done and going to do. So not tons of optimism, but hopefully we'll make it through. JoAnne, please help me out. Something cheery.
I think I would strike a hopeful note, but on the realistic side, I would agree with Chloe and Craig, it's going to be a real slog. I actually think the Supreme Court is a pawn in a political power play in this nation. And so to Chloe's point, I think that the real answer is, I have to believe that Americans are going to step up and say, hold on, even if historically they have sort of been asleep at the wheel. Some of that's going to require, I think, better civic education in the K through 12, easy to say, hard to accomplish, especially in challenging cities like ours where we don't have a lot of extra money. But I think alerting people to the significance of these issues is going to be a start. But I think ultimately people are actually going to say, I don't think this is the way my country should be working. And I would agree that the answer isn't probably going to take place at the Supreme Court. These people, should they have long lives, which my faith tells me I should pray for, they'll be there for a while. So I think that the change that we want to see is making our voices heard at smaller, more local levels, where we begin to take back the country we care about. It's going to be an imperfect process, a step forward, a step back. But I do think that this nation is poised to do it, but there is this overlay of power that I think has really changed the dynamic. And that I think needs to be recognized and talked about. We don't have time today to talk about some of the responses to that. I'll only raise one. One possible knee-jerk reaction might be term limits, that we basically are electing new politicians all the time. I think that's easy to say and hard to bring about. There's a lot of reasons why you can't get people to give up a career to go for something that's temporary. So I think that's a debatable issue, but it's the kind of thing we ought to be talking about. What are the right solutions to this? Because to Greg's point when he first introduced this, and to Craig's and Chloe's points as they talked about how decisions should be made and the history of decisions. You know, this is a nation that thrived on the rule of law. I am so proud of it, having taught in many international countries where that's not the norm. They at the time looked at us with such admiration because we were a nation where law ruled everything else. That's the part that I feel is under assault and that matters enormously. And I hope we can get back to the point where, as Chloe said, the court has not just a sense of legitimacy, but a perception of legitimacy. I think it is crucial, not just for the court, but for our nation.
Thank you. I think that we just heard a lot of very insightful comments, and I would say, you know, I share Craig's short-term pessimism, but also JoAnne's longer-term slice of optimism. I am optimistic that the nation, in a sense, will find a way to correct course, although I certainly don't claim to know exactly how it'll chart that path. One of the things that's gone through my mind in thinking about preparing for the discussion today is that, as you've heard, the founders designed the court to be somewhat above politics. That was a very intentional decision, so the public doesn't have a direct say in the appointment of the justices. The terms are for life, as JoAnne just alluded to. And in that regard, it was designed in that way for a very specific reason, which was to be counter-majoritarian. But in the framers' eye, it was to be counter-majoritarian in order to protect individual rights against the potential tyranny of the majority. And so it was meant to stand as a bulwark in that regard. But this great strength of the court in being at least partially above politics, or being intended to be at least partially above politics, and having independence from what might be the whims of the majority of the electorate in any given moment, that strength is also a weakness, right? As is often the case. And it's a weakness institutionally, because if the court can be manipulated by politics, then it's the perfect institution in which to do that and to pursue counter-majoritarian goals. And so, you know, there's a institutional governance challenge here, where the framers took one approach, and we're seeing the way it's playing out right now, that creates the challenges around legitimacy. So as promised, I appreciate you giving us time to share some of these initial thoughts. Hopefully it's been useful framing. I've appreciated a number of comments that people have shared in the chat. I'll let my panelists know. We've gotten a lot of folks have appreciated everything you have said so far, and found it insightful and helpful. I've gotten a couple questions so far from all of you that I'll begin with, and feel free to send in more as we go along. I think maybe one place to start is that someone raised the question of the court thinking about the structure of states' rights versus federal interests and federal power, and that may affect some of their decision making, and wanted to get folks' thoughts, our panelists' thoughts, on how you balance state interest against federal power in the judge's decision making, and whether that aspect you think forms a background to some of the decisions that we've seen recently. Craig, I saw you blink.
I'm obsessed with federalism, so I'm going to be as short as I can.
I knew that too.
Yeah, the most recent Law Review article, I published a new one coming out about federalism. And the thing I want to say about states' rights, because that's what I want to call it, states' rights, is states' rights, in a certain sense, is the oldest. It's been called the oldest question of constitutional law, because states have been around kind of since the beginning. I think I would want to add, it's been one of the ugliest questions of constitutional law, as states have had a peculiar role in racial injustice and violence. If I could quote PG-13, Nina Simone, Mississippi goddamn is I think what she might have said. And I think that there is a real history to states' rights that I think has been handled delicately by modern advocates, if that's the right way to say it. Fine. So the new court, it's absolutely a great question, because the new court, one of their things they're pushing alongside the other things we've discussed, and an increased role of religion, which I think we haven't mentioned, but it's states' rights. And they want to do it as though it were originalist, which is to say all the way back from the 1700s. And it's just not true. And so a lot of the arguments that one sees reference history, but with no history. So like the Organization of American Historians and the professional historians are all writing briefs in these cases on the other side. And in the Supreme Court supermajority, what I'd like to call the Trump era conservative supermajority, make it trend. The Trump era conservative supermajority uses its own imaginary fiction of the history of statehood to impose that model of states' rights in the face of a national political judgment. That's what happens, is there's some national political judgment, the court discovers states' rights, and the national political judgment gets kind of thrown aside in the service of the fantasy of states. And so I think and that happens, sort of time and again. It's absolutely a theme to keep an eye on, even if it's not quite interesting enough. I think that's probably fair to get its own teach-in, probably not. But I think it is really a feature of the thing, and I think it really has a perniciousness to it. These questions of process that you were raising before, the judicial decision-making process. Chief Justice Earl Warren always used to say his guiding principle was, how is this fair? And I think the modern court could do with a little more of those questions and a little less of conjuring up mythologies and imaginary traditions that weren't until they discovered them in their own minds and breakfast rooms.
Chloe, did you have something you wanted to add there?
Yeah, I mean, +1 to everything Craig just said there, and part of the problem with this particular court's legal arguments, if we'd like to call them that, historical arguments, if you'd like to call them that, is that they don't always feel like they're being done in good faith, and in part for these sorts of reasons, right? You say history supports my view, but then you offer no evidence about it, and then there's inconsistency that also seems to belie some bad faith principles, right? We're seeing the court say that states' rights are paramount to them, and we see it in discussions around abortion, right? States should have the ability to make that inaccessible to people. But then we also at the same time have a law around guns in New York, right? So there, states aren't supposed to have power to make decisions to limit access to guns. And when we see two very similar kinds of cases being argued on states' rights grounds and the court going different directions based on what look like their small p political preferences, it undermines the legal arguments and certainly undermines the legitimacy of the court in general. I think they would do well to try and be a little bit more consistent at the very least in how they're approaching federalism.
Thank you. Another question I got is focused particularly on legitimacy, and we talked a little bit about sort of any hope for the future in change, and this was asking us to focus a little bit more on legitimacy specifically, and whether there's any way that we see for the court to right that ship. And as we've talked about, legitimacy, the perception of legitimacy is particularly important for the court because the Supreme Court has no way to enforce its decisions. Its legitimacy is the means by which its decisions have an effect, essentially. And concerns about the court's legitimacy is something that's been raised by several justices on the court, both on the left and on the right, recently, sometimes in decisions themselves, in the writings themselves, as well as in talks. What do our panelists think? Do you see an avenue towards the Supreme Court regaining a sense of a perception of legitimacy among the public?
I'll offer two quick thoughts. The first and most easiest to identify is that we would see decisions from the court that seem more defensible to whatever political listener is reading the decision. I think Chloe hit the nail on the head, and so did Craig allude to this. A lot of the reasoning leaves a lot to be desired. That's something the court could do. They could try to persuade through their writing the legitimacy of their decisions. But to the point I made earlier that I think they're a little bit of a pawn, I think that, and it's interesting, Greg, I really didn't know, because I don't do history, that's why I have Craig. I didn't realize that we had so many disputed nominations in the 19th century. But at least in the most recent past, both political parties set aside their own preferences for who they might have wished had been nominated and judged the nominee on the nominee's background and credentials and capacity. We've left that. We left that in the starting gate. And I think if we got back to that, we would be then seeing more justices seated who people on both sides could be brought along to respect. Right now, we're all trained to be skeptical. And that's not the justice's fault. That's the Senate's fault.
You mind, JoAnne, I wanted to ask you, because there's something I'm not sure people may necessarily know. I mean, you had been considered as one of the possible Supreme Court nominees, and you participated in Justice Sotomayor's hearings. And I just wonder, having sort of seen it up close and personal, what your thoughts were from that experience. And then I think, maybe the Trump nominees, some of them had personal issues, some of them got swept up in maybe the Trumpiness of it all. And then I think, what you would think about that same, what the Senate's role is, I think Greg had mentioned with respect to the newest justice, and sort of what was sort of your perspective on the Senate's behavior in kind of recent years?
Well, thank you for that acknowledgement. It was kind of cool to make the list, but I never got nominated, so I didn't have a personal participation in that process, but I did get to testify for now Justice Sotomayor. I got to see it from that perspective, and but I saw it from the hearings perspective, a little less so from the background. But I think to your point, Craig, right now, I think an interesting conversation would be the extent to which a justice's personal foibles, if we might call them that, should have a place in whether they get confirmed or not. I don't think the answer to that would be uniformly judged by Americans. I think it's a great conversation. So I think that's a place where the court has most recently decided, I really don't care, like they're imperfect, we're all imperfect, oh well. That's true, we are all imperfect, but we are imperfect in different ways. And so one thing to think about is whether our imperfections have anything to do with either our ability to be good justices or the perception that we will be good justices. And in that regard, the nature of the imperfection to me matters, but others might disagree, and I could be persuaded otherwise. I also think that the speed with which some of this was done just feels as if it has an outcome determinative process. We didn't use that phrase this hour, but I think that that's one of the things that historically the Supreme Court and the federal courts tried to eschew. They tried to do the right thing. They didn't take a case, they're like, yes, finally got that case when I get to do X. That's where people feel we're headed or have actually arrived. So I think that there are a variety of ways in which legitimacy can be restored. And the court has only a part, but not the whole part.
Thanks.
Great. So I see we're at 3 o'clock, and I know we're sort of losing some people to other engagements, but I would like to indulge folks and take one more question before we wrap up that I think would be a useful one to touch on, and also maybe an advertisement for some of the teach-ins to come. And that's a question about the decision in Dobbs, and a feeling that it, in the question asker's words, blows right past stare decisis, without providing too much explanation on that. And we're asked, are there other historical cases of overruling such major judicial precedent? In what cases might such overruling be justified?
Brown versus Board.
Yeah, so well, I mean, I think it probably jumped all of our minds. JoAnne, will you talk about that a little bit? You're on mute.
I'll just be really brief, but I think that the mindset that led to that decision would have struck many people as, doing great deference. Great disastrous consequences to the president, because they basically got thrown out. But as Chloe said, it was to give more rights. Maybe that doesn't matter at all. I use Brown as an important placeholder in my life. If I'm not prepared to talk about it and defend it and explain it and try to put it in context as defensible, then I shouldn't be a part of this. I think one can do that. But I think Brown versus Board of Education is a great example, because for the 50 some odd years before that, separate but equal was just fine.
And to add to that, I think Brown is such an instructive example. It was the court was very self-conscious about how they went about it, right? There was Brown 1 and Brown 2. There was the separation between making the actual decision, knowing that that was going to get serious political and public backlash. And so letting tempers cool before they figured out or released how they were going to actually implement the decision. There was active lobbying within the court to make sure that the court showed as a united front, again, knowing that this was going to be a big change, that it was going to upset a lot of people, making sure that everyone was bought in. They had convinced the entire court and come up with the consensus decision that everybody could support. And we see, not just the difference that this was an expansion of rights rather than a contraction of rights, but we see the difference in how seriously the court took its own legitimacy, how seriously they took the process of trying to make sure everyone's on board before we make such a huge change, and that we have the teeth to make sure that it's going to be implemented. Now, the implementation questions were problematic in what the court provided, and also in the way that the other branches responded. But compare that now to Dobbs, right? We have a court that a majority pushed it through, where there was significant disagreement, where it was very clear that they wanted to get it out fast, and not so concerned with how it was going to be received by people who disagreed with it, or people whose lives are going to be changed as a result. But I love the contrast there for those reasons.
Yeah, and a little bit of a different point, but I think the kids used to say, hit like and click subscribe to this channel is what I would say, because I think it's so encouraging, the idea that our intellectuals at this university and the future citizens are paying attention in a structured way, in a real forum, and it's something that I think JoAnne was really emphasizing earlier, to pay attention to these really important issues that are affecting Temple and affecting Pennsylvania and affecting America and affecting generations. And so I think that's totally amazing. And the sort of second thing is, of course, although maybe not everyone wants to hear it, I mean, some of you folks who are undergrads will be law students, and some of the law students will be judges. And so whereas some of us are called upon to think about and criticize and analyze and assess and react to the current, I think there's a real sense in which the future is not written, where this was Chloe's reminder at the beginning of our discussion that things really have changed over time. And in a generation or another generation, it may be too late for me, but it's not too late for you. And I think there's a real sense in which these questions about fundamental values and fairness and liberty and equality and states, these are questions that are in very important ways over a broader arc, whether it tends toward justice or otherwise. And a longer arc, they really are for you folks to write. And I think to have you be informed and to have you be thoughtful and have you be discursive and having a conversation about it, I just think it's so encouraging. It's sending me off the weekend with a big smile.
That's fabulous. And I think a wonderful place for us to wrap up, though we're hardly finished with the topics we've started to talk about today. We are finished with our time. And I want to add my voice of deep gratitude to all of you for joining us today, particularly the students who are interested in these topics, interested in learning more about them, interested in becoming involved and active with respect to them. I think that's exactly what Temple Made is all about. And so thank you for taking that time on, as Craig said, a beautiful Friday afternoon. I'm also very grateful to my colleagues who agreed to spend their time on this panel. Thank you, Chloe and JoAnne and Craig, for enlightening all of us and sharing your thoughts and your wisdom and your insights. And thank you especially to Ralph for inviting us to be present and allowing this to take place. And I will turn things over to you to wrap things up.
Yes, wanted to thank all of you again for doing this panel. It was really very illuminating discussion, and of course the students. It's always great. It's one of the things I love about teaching at Temple is that students seem to be very concerned with the world that they're inheriting, and are very willing to come to these discussions and talk about these things. I'll be, when I get the link for the video and recording this, I'll send this to you guys. And I know that I think the law school is planning to put up a site where all of the videos that will be dealing with this topic will be posted later on. And there is also a Facebook page for the teachers where I usually will post the videos as well. So again, thank you all for coming. And next week's teaching is going to be on climate change. It's going to be on Thursday rather than Friday, which is usually they're on Friday, but this one's going to be on Thursday, and it will be featuring Mohammed Kiani, who is a professor of engineering at Temple. He's a scientist, and Professor Sinden, who's from the law school. So thank you all for coming, and see you around campus. Ciao.